There you go. Okay. All right, Mr. Wallace, you're up.
Thank you, Your Honor. Okay, please the court. My name is David Wallace on behalf of Northern Trust from the Bentley and Bruning firm in Sarasota. I'd like to reserve 4 minutes for rebuttal. This case involves the misuse of the statement of claim process in probate in that Rebecca Walker did not have a valid claim, but needed to file a statement of claim in order to trigger a power of appointment. As stated in her statement of claim, Rebecca Walker did not want the debt to Northern Trust for the Northern Trust loan to be paid out of the Charles Walker Trust from the pledged assets specifically reserved for that purpose. Rather, she wanted the Northern Trust loan to be paid out of the Elizabeth Walker Trust through a power of appointment.
Mr. Wallace,
But in order for that to be triggered,
Mr. Wallace, before
yes,
we get into the merits of the appeal, can you address this court's jurisdiction under Rule 9.170? In looking at the trial court's order here, the order doesn't appear to end judicial labor, nor does it allow the claim or deny the claim. And so it leaves open a matter of whether or not Ms. Walker was a reasonably ascertainable creditor, and it allows for additional discovery. So how does this court have jurisdiction?
well, Your Honor, this is the first point is that additional discovery that you refer to was to take place in the context of the independent action that
Well,
could never.
I don't know. I don't read that into the order. I certainly am aware of the independent action, but it doesn't dispose of the claim either by saying that the claim is allowed or that the claim is denied, which is very distinctive from the cases that you recited in response to our order to show cause.
Well, Your Honor, what the order did do is it did not grant the motion to strike. It did not rule that the claim was untimely. It did not rule that it was fundamentally flawed. And by doing so, by that point, the independent action had been filed, and in fact has been proceeding forward in another court for months and months now. And our position in our jurisdictional brief, we referred to the Smoke case in particular, Your Honor, and some of the other similar cases, is that when the ruling takes the matter to another court, then that is the jurisdictional ruling. Now, I hear what Your Honor is saying about that he made reference to the additional discovery, but there's been no further activity in the probate court. All the further activity has been in the.
Mr. Wallace, the fact that the parties have decided to litigate in the independent action and have taken that order as instructions to do so and have done so, it's really not for our purposes here. I guess the question that I had on jurisdiction has more to do with the fact that the probate court is the one that has jurisdiction to determine the sufficiency, whether the actual claim is legally sufficient. Would you agree with me with that?
Yes, Your Honor, and whether it was timely.
And the merits of that actual claim are to be determined by the circuit court where the independent action is actually brought. And so the order that leaves open that the court can't make the determination of the sufficiency, the legal sufficiency of whether or not that claim is indeed a claim, I see that as a jurisdictional issue. I understand the parties have dealt with it differently, but I see that as not an end of judicial labor where the sufficiency of the claim, whether it can be brought or not, and whether she is standing to bring it is really a matter for the probate court's jurisdiction that hasn't been determined yet, because there's been no allowance of the claim in the order, and there's been no denial, just simply an order denying the motion to strike.
Well, Your Honor, all I can say to that point is that, as you alluded, the parties all took the order to be go forth with your independent action, and that is in fact what they've all done.
But you would agree with me, the order itself does not say that.
I would agree with you that the order is somewhat ambiguous on that point. I know from the.
No one sought clarification of the order?
Not to my knowledge, Your Honor. No, I've not seen a motion for clarification. I know that the parties all regarded the independent action as having been commenced and went forth into that forum in circuit court, leaving behind probate court, which is the basis of our jurisdictional point, is that it left behind probate court and moved on to another court. I understand your point. There was no.
Let me ask you this then. So the determination of whether or not Ms. Walker was a creditor, you're saying, and that's in the probate context, you're saying that the circuit court is the one to make that determination?
I'm saying our read of the order is that the probate judge allowed the independent action to go forward, which by its very nature, you can't have an independent action going forward as if it's not timely. The statutes say that. You can't have an independent action, in our view, go forward if it doesn't meet the fundamental requirements of a claim. In our view is that by the independent action going forward, that has determined that issue, not in the circuit court, but in the probate court, by virtue of that court allowing that to go forward.
Well, I guess, and that's what I just don't understand, because if the court is going to allow additional discovery to go forward, it doesn't come back to the probate court for determination on the merits of the claim.
And our view is that that the merits of the fundamental merits of whether this is a claim should have been determined by the court in the context of that motion to strike in the probate court, and that by the very language of the statement of claim itself, the probate court had more than enough to make that determination in that setting, and that's where it should be made. And absolutely, it's clear in the statutes that the timeliness issue is a matter of law for the court in the probate court, because of independent action is not even allowed to proceed if a claim is not timely.
So if we decide that the case should have been stricken at the probate court, what effect would that have on the independent action?
Our view is that it should be dismissed.
So if we take jurisdiction and decide the issue, then that would end the case.
It would end the independent action, Your Honor. That is our view, yes. Because it could not have been brought as an untimely claim, and it should not have been brought on a fundamentally flawed statement of claim without a liability of the decedent, etc. Yes, Your Honor.
So your understanding, though, of the probate order is that the probate judge was asking for discovery to take place in some other forum.
That is our understanding of it. Yes, Your Honor.
That certainly could have been made clearer if that's the case.
Well, of course, I guess we're all here talking about it, so I guess we would, yes, it would have been more, it would have been better if it was more clear on that point. I agree with you. But our reading of it is, and certainly all the parties' actions have been, that everyone's proceeded with the independent action.
So suppose we decide that we don't have jurisdiction. Does it really make any difference? Because you have the independent action going forward anyway. So what difference does it make? Would that make the probate case go away?
Well, the probate case was just the stepping stone to the independent action. In the sense that there's a probate, of course, and then there's this claim in probate. So the claim in probate was the stepping stone to the independent action. So I don't think that is a solution for us to say, just resolve it in the independent action. If it were to be sent back to probate to clarify this order and rule up or down on whether it was timely more clearly, which we believe it was clear that they allowed the independent action to go forward, but we don't believe that just proceeding with the independent action is a solution, because it shouldn't be there if it's not timely and if it's not a fundamentally sound claim.
Okay, thanks.
Your Honor, I don't want to leave the jurisdictional question until I'm sure I've answered your questions. I know that there's some questions that may be unanswerable today, but have I addressed your questions, Your Honor? Have we addressed jurisdiction to your satisfaction? Thank you. So we're back to the point that what we have here is a misuse of the claims process. She needed a claim in order to trigger the power of appointment. Northern Trust, everyone agrees this. This is clear from the hearing, clear from the papers below. Northern Trust did not have to file a claim. They had a fully secured claim with pledged assets sitting in the Charles Walker Trust. They accessed those assets, paid off the claim, extinguished the claim, did not have to extinguish the debt, rather, did not have to file a statement of claim, and did not file a statement of claim. Because Northern Trust did not file a statement of claim, there was no claim to trigger the power of appointment. Rebecca Walker filed a statement of claim. Her statement of claim answers a lot of questions, in my view, for this case, because she tells you why she filed it. She filed it to object to the payoff of the pledge loan, the Northern Trust pledge loan from the Charles P. Walker Trust. Filed it to object, but she does not, in her statement of claim, assert that she's a creditor with a corresponding liability of the decedent. Those are the, obviously there's some other technical requirements for a statement of claim, but those are the two most fundamental, in my view, requirements for a statement of claim. Is you need to be a creditor, and there needs to be a corresponding liability of the decedent. And those basic elements are missing here. In addition, and I'm going to get back more to that, but in addition to the fundamental validity of the claim, if you will, the statement of claim was not timely. It was filed, I think it was about 10 days after the expiration of the 90-day claims period that was initiated by Rebecca Walker while she was the PR. So she had actual knowledge of that claims period and actual knowledge of the expiration of that claims period, and knows that her claim was filed after. I noted that there's no dispute but the Northern Trust didn't have to file a claim. I wanted to give you one quote from the hearing. This is from counsel on behalf of Rebecca Walker. He stated, "And I agree, they," referring to Northern Trust, "have the right not to file a claim if they don't want to." So Northern Trust was under no requirement to file a claim. That's also pursuant to Florida Statute Section 733, 702, 4A. With regard to the particulars of the claim, again, this is not a matter of magic words or it having to be so specifically proper. This is the problems with this statement of claim are fundamental. Florida Statute Section 733, 2014 says that a claim means a liability of the decedent. In this instance, excuse me, there is no liability of the decedent alleged in this statement of claim. To the contrary, it says several times that the liability of the decedent was paid off. The Northern Trust loan was paid off. That's what she has the objection to. But the liability of the decedent is the most fundamental part of what a statement of claim is about. So there is no liability of the decedent alleged. And in fact, as I say, to the contrary, she's alleged that there is no liability of the decedent. Now, Rule 5.490 in Florida Statute 733-7031 make clear that a creditor shall file a claim. She doesn't allege that she's a creditor. Again, back to the most basic, an average statement of claim would say, I am Mr. Smith and I am owed X amount of money from the decedent from that estate. Those basic elements are missing from this statement of claim. Again, it's not magic words, it's a very low bar, but she didn't meet the low bar. Rebecca Walker, through counsel at the hearing below, and then also in the brief, has what I will refer to as their transference argument. Rebecca Walker argues that when Northern Trust paid off the Northern Trust loan by application of the pledged assets to the loan, again, the pledged assets that were there for that purpose, the debt was somehow transferred to the Charles Walker Trust, making the Charles Walker Trust a creditor of the decedent's estate. But I want to be, absolutely clear here. The decedent's debt to Northern Trust was not transferred. Northern Trust, the debt to Northern Trust was extinguished. It was paid off. It was not transferred. Nobody else owes that debt to Northern Trust. It's gone. And I would also add that the transference argument is an after the fact justification for this. The transference argument is not in the statement of claim. The statement of claim, as I referred to earlier, primarily just registers an objection, but doesn't state that $1.4 million is owed to the Charles Walker Trust from the Charles Walker estate. And on that point, even if it said that, that's one hand taking money from the other hand. It's circular. And it's circular because Florida statutes tell us, 733-707(3), that if the estate can't pay its debts, the trust has to pay it. So here we have this suggestion, again, not in the statement of claim itself, but in the brief and in the argument below, that the trust is a creditor of the estate, but that really can't be because the trust has to actually pay that money if the estate can't pay it. So it's one hand demanding money from the other hand, and it doesn't work. I would like to address the timeliness issue. The first point I want to make is that this was a claim that was a claims period that was expired and that they have attempted to revive. The claim expired after the 90 days had run, and the attempt to revive it was through a 30-day notice to creditor sent by Rebecca Walker's sons, who were substitute PRs, sent after the expiration of the 90-day claims period. Now, that 30-day notice is only sent if the party to whom it was sent is a known or readily ascertainable creditor. So this is the Charles Walker estate sending a notice to the Charles Walker Trust after the expiration of the 90-day claims period saying, we now know you're a known or readily ascertainable creditor. But as we've just been through the discussion, the Charles Walker Trust is not a creditor at all of the Charles Walker estate, and particularly not a creditor with regard to the Northern Trust loan because it was paid off a month or so before the claim was made, before the notice was sent. So that's an effort. And of course, I don't know why the claim wasn't filed within the 90 days. It could have been. Rebecca Walker resigned as PR. Her sons took over as substitute PRs. the Northern Trust loan was paid off, and then there were several weeks left before the expiration of the 90 days. Our view is that as a matter of law, from the face of what we're seeing here, the claim was just flat out untimely, and that the effort to revive it must fail for two reasons. One is the reason I've just been through, which is that there is no creditor, that the Charles Walker Trust is not a known or ascertainable creditor because they're not a creditor of the Charles Walker estate. And second is that these notice provisions are all for due process purposes. And the cases we've cited to address that due process is satisfied by actual knowledge. And
Mr. Wallace, you are down to 4 minutes, and that is, I kind of reset the clock when we finished that jurisdictional discussion. Okay. And so you still have your 4 minutes if you want to save them for rebuttal. And also,
I will save for my rebuttal. Thank you.
Also allow 3 or 4 minutes to Ms. Silverman if she wants to discuss the jurisdiction question, if she wants to. And your mic is turned off, Ms. Silverman, so you probably ought to unmute. There you go.
Am I okay?
I've always said you're okay, Ms. Silverman.
All right. This is my first remote oral argument, so I just want to make sure I'm seen and heard appropriately.
Absolutely.
Thank you. My name is Susan Silverman, and I am honored to be representing Rebecca Walker today, individually and as trustee of her late husband's trust, the Charles Walker Trust. I'm not going to spend too much time on jurisdiction, other than the fact that it is kind of a quirky procedural quagmire we're in, because the 9.170B does allow an appeal as a final order of an order determining a motion to strike an objection to a claim. But here we have a motion to strike the actual claim.
Can I ask a question about, on this jurisdictional issue? Would it be conceivable that, and I realize we're in a specific procedural posture, but it would be conceivable that the failure to strike a claim that wasn't a final order for purposes of appeal could be a departure from the essential requirements of law for purposes of certiorari? It's an academic question, really, perhaps.
I mean, I really haven't given that aspect.
Yeah, I get it. That's why I'm giving you guys extra time.
Okay. I mean, my initial, well, I will be in all candor to the court. When I saw the order to show cause, I was surprised by it, because had I not thought that it was an appealable final order,
You would have filed a motion.
Dismissed before we went through the briefing process.
Right.
But, I did feel at the time that the judicial labor in the probate court was finished. But to judge.
Second part to that rule, that there's a part of that rule that talks about the rights and determination obligations of the parties. And so the motion to strike is simply denied. And I take it the parties have inferred from that the court, by denying the motion to strike, has allowed the claim. I can only assume that's what the parties have taken. But in just simply denying a motion to strike, what determination, other than some inference that the parties have, where did the court in the order or somewhere in the transcript determine the rights and the obligations of the parties so that would allow us to have jurisdiction?
Well, I guess in response to that, I would say that because the rule that allows, or the statute that allows an independent action to proceed within 30 days after an objection, that statute says that the claim must be timely. So I would say, as far as the timeliness issue, you know, they ruled it was timely, and that
That's not necessarily what the court ruled. The court ruled deny the motion to strike on untimeliness. Further discovery is needed. So, and I could be interpreting it wrong, but I only have, you know, the order that I have before me of what the court did. And so I don't see where the court determined the timeliness of the claim, other than to say that further discovery was necessary, which leads me to believe the court didn't have enough information before it to determine the timeliness, which is certainly.
Well, in an attempt to answer that question, I will say this. I believe that the order did say that Rebecca Walker was a reasonably ascertainable, known or reasonably ascertainable creditor. And if that's the case, that is what will determines that the statement of claim was timely, because she was a reasonably ascertainable or known creditor, she had to get actual notice, which she got on December 3rd. The actual notice to creditor was served on her on December 3rd, and her statement of claim was filed December 12th. So if indeed she were determined to be a reasonably ascertainable or known creditor, then it follows, just based on the statute, that that her claim was timely.
Okay, so we start on the merits now?
Yes.
Okay.
Thank you. Thank you. And I would like to address Mr. Wallace's points in order of presentation, but before I get there, I just want to start with the fact that nowhere has it been mentioned what the intent of the parties were throughout the drafting of the trust documents, the decedent's will, the exercise of the testamentary power of appointment, and the intent of both Elizabeth Walker and her son, Charles Walker. So Rebecca Walker was the surviving spouse of Charles. They were married for 27 years, and she believed that the loan related to the Roberts Point Road residence, which is how this loan began to Northern Trust back in 2003, was required to be paid out of the assets of Mr. Walker's mother's trust rather than his own trust. The problem with Northern Trust's position is that it is contrary to the intent of both grantors, both of whom were clients of Northern Trust. Northern Trust maintained both accounts. It was the trustee of Elizabeth Walker's account and was the financial advisor for both trusts. Elizabeth Walker's intent was for her son to enjoy a testamentary general power of appointment to direct payment in favor of creditors of his estate out of her trust assets. Article 9 of her trust granted Charles Walker the power of appointment. He exercised that power in paragraph 1.5 of his will. Northern Trust knew about the grant of the power and the exercise of it. It was the trustee of Elizabeth Walker's trust. Charles Walker's intent was to ensure that Rebecca and his spouse of 27 years and the sole lifetime beneficiary of his trust would be able to live out the rest of her life with financial security and maintain the standard of living he had provided during the marriage. The grantor's and testator's intent is the pole star of trust and will interpretation, which is determined from the plain and ordinary meaning of the terms set forth in the trust and the will. As to the argument that Rebecca Walker is not a claimant and not a creditor. I will say this. First of all, the statement of claims substantially complied with Rule 5.490, containing the information contemplated by the rule, and was sufficient to notify the interested persons of its substance. It furnished sufficient information of the extent and character of the claim. What makes her a creditor is the fact that she individually is the lifetime beneficiary of the Charles Walker Trust and of the income from the funds that were removed by Northern Trust to the tune of $1.4 million. The statement of claim does not specifically state that she is owed that money, but she was entitled to income from that money as the sole lifetime beneficiary of the trust, and that money should have remained in his trust and taken from Elizabeth Walker's trust. What makes her a creditor as trustee of the trust is that the debt of the estate was transferred to and became the debt of the trust. Mr. Wallace disputes that fact, but I would submit that the trust became a creditor because once Elizabeth Walker's trust didn't pay Northern Trust debt, and the trust did, it was owed money from Charles Walker's estate. If Rebecca Walker was not permitted to submit a statement of claim, she would have no remedy available to right or wrong to the trust. Mr. Wallace also argued that she had no claim against Charles Walker and he had no liability to her at the time of his death. Northern Trust was the creditor and not Rebecca Walker. Yet the claim was based on a known liability of the decedent to Northern Trust, and the satisfaction of that claim significantly reduced the funds available for Rebecca Walker's lifetime support. There has to be a remedy to right that wrong, and I would submit that a statement of claim is that remedy. And that should particularly be so under the circumstances of this case, where it appears from the record that Rebecca Walker was not aware of the pledge agreement of 2015, which changed the collateral that was securing the debt. So essentially, she was lulled into a false sense of security that Northern Trust would file a claim in Charles Walker's estate, thereby triggering the application of the power of appointment. Now, I agree with Mr. Wallace that there was no requirement for Northern Trust to file a statement of claim based on the collateral available, but at the same time, they knew of the power of appointment and the testamentary plan that was in place to satisfy that debt, which was out of Elizabeth Walker's trust. I mean, Charles Walker had a testamentary plan in place to satisfy that debt, and his intent could not be clearer because on January 30th, 2007, the property that was the subject of the debt to Northern Trust was deeded by trust deed into his trust. That was the same day he executed his will, which exercised the power of appointment given to him by Elizabeth Walker's trust. The clear intent was for the debt to be satisfied by assets in his mother's trust upon his passing. In 2008, in furtherance of that testamentary plan, Rebecca Walker was removed as a co-obligee on the debt related to the real estate to pave the way for Northern Trust to make a claim against the estate. There is nothing in the record to suggest that when Northern Trust asked Charles Walker to execute a new pledge agreement in 2015, that his testamentary plan had changed. It never did. He was simply following Northern Trust's advice in executing the pledge agreement. When Northern Trust satisfied its debt from Charles Walker's trust assets, it was the trustee of Elizabeth Walker's trust, a creditor of Charles Walker, and a successor trustee of Charles Walker's trust. The intent was not honored by his financial advisor. Regarding the timeliness issue, I think I addressed this briefly in my jurisdictional point, but to reiterate, the time limitation of 733.7021 does not apply to known or reasonably ascertainable creditors. She was a known or reasonably ascertainable creditor because after Northern Trust took the assets out of Charles Walker's trust, Rebecca Walker at that point in time knew there was a claim to be made by her as trustee of the estate. Therefore, the 3-month period doesn't apply. Now, I think it's important to point out that the assets from the trust were not removed until November 6, 2018. By that time, Rebecca was no longer personal representative of the estate, and at that point, she was aware of the claim. Her statement of claim was required to be filed 30 days after service of the notice to creditor. And here she was served with that notice on December 3rd, 2018, and her statement of claim was filed December 12th, so it was timely. Now, the argument that because she was personal representative of the estate, gave her knowledge of that claim back when the estate was opened, I do not agree with, because the opening of the estate per se does not bind her to the 90-day limitation. When the estate was initially opened, she did not have actual knowledge of the basis of her claim because that debt was not paid until November 6th. So while she had knowledge of the estate being open, she did not at that time have knowledge of the payment being made contrary to the intent of the grantors. And the estate of Denise case, which was relied on in appellant's brief to support its argument that Rebecca's claim is untimely because she knew about the opening of the estate, I would dispute that that's what that case says. What it says is the actual knowledge requirement applies to knowledge of the information necessary to timely file a claim, as opposed to solely the status of being the personal representative. And in this case, that knowledge was not gained until November 6, 2018. So further, in the Denise case, even though a separate civil action had been filed, there had never been a claim made in the estate before the estate was closed. The filing of the statement of claim was really the only remedy Rebecca Walker could have pursued within the probate proceeding. How else could she have brought before the probate court her objection to Northern Trust's actions in paying the loan out of Charles Walker's trust instead of Elizabeth Walker's, contrary to both of their intentions? The purpose of both trusts was frustrated. Either way, Northern Trust was going to get paid in full. The probate court did not abuse its discretion in denying Northern Trust's motion to strike Rebecca Walker's claim based on the totality of circumstances. It was reasonable for the trial court to take the view that her claim was timely and that she was a known or reasonably ascertainable creditor. Equity and fairness toward Charles Walker's surviving spouse support the court's ruling. Otherwise, there would be no remedy or recourse available to her to object to that payment. The civil proceeding is pending in the circuit court, subject to a stay pending the outcome of this appeal. It was timely filed within the 30-day period of Northern Trust's objection to her claim. The probate court correctly ruled that further discovery was needed regarding her claim and that the action should be allowed to go forward. And ultimately, the circuit court should fully litigate and determine the validity of the claim. So I would respectfully submit that this court should affirm the order denying Northern Trust's motion to strike Rebecca Walker's statement of claim in all respects and allow the claim to proceed in circuit court. Thank you.
Thank you, Ms. Silverman. Mr. Wallace?
Yes, Your Honor.
Could I ask you one question
Yeah.
as you're starting? Given the nature of the claimant's dispute with what happened, how would she have raised that otherwise?
I hear you. I'm not sure we're required to answer it here. I think what we really need to answer here is whether it fits within the statement of claim process.
I get it. I understand that.
I will try to answer your question as best I can. I actually think that first of all, that it doesn't fit the statement of claim process. Excuse me, something popped up on my screen here.
Yeah, it happens to me too.
There we go. It doesn't fit within the statement of claim process, but I don't think it's accurate to say that there is blanket, as Ms. Silverman said, no remedy. I think that there might have been some other structure. I think they tried to fit a square peg in a round hole. I think that there could have been I don't want to use the word claim, there could have been a complaint filed, for example, by the estate of Charles Walker. What they've done by the statement of claim process is filed a statement of claim against the estate.
Right.
And I don't think that's fitting the facts or the law. So I think that there is, I haven't tried to draft an alternate remedy for them or anything like that. I don't agree that there is no alternate remedy, and I don't think it would, but I just think it wasn't a statement of claim. And further to that point, as I heard the argument about how it might fit the statement of claim process, what I never ever heard is where is the liability of the decedent? The liability of the decedent. The 731-2014 claim means a, quote, liability of the decedent. There is no liability of the decedent underlying this statement of claim. There's an objection. There is her position, Rebecca Walker's position about what should have happened, but there is no liability of the decedent. And again, I apologize for repeating myself. She says in her statement of claim that the Northern Trust loan was paid off, and being paid off means it's gone. There is no liability of the decedent. That is the most crucial element that has to underlie a statement of claim. It's not there. And I do think that there might have been some other remedy had they pursued it, and they might yet pursue it, but it's not through the statement of claim process. And I go back to where I started, which is Northern Trust was not required to file a statement of claim with regard to the pledged assets. They didn't. Everybody agrees they didn't have to. But in order to trigger the power of appointment, Rebecca Walker needed a claim. So they tried to do the square peg and the round hole and put whatever objection and whatever position she had into the form of a statement of claim, but that doesn't make it a statement of claim. Judge Smith, back to the jurisdictional point, I think I understood Ms. Silverman to say that she agreed or at least understood the legal requirements of the probate court to have been concluded, and that it had moved on to the independent action. And in fact, I think I understood Ms. Silverman to say that she reads the order to have determined the timeliness of the claim. And as I said before,
I also said she reads the order to determine that Ms. Walker was a reasonably ascertainable creditor, which the order does not.
I agree with you on that point, Your Honor. I do not agree that she was that the order. I think that was a recitation of their position.
It didn't determine timeliness. It didn't determine that she was an ascertainable creditor as well. So,
well,
therein lies the dilemma.
I'm sorry, I didn't understand you, Your Honor.
Therein lies the jurisdictional issue.
Okay.
Because and just to go back to this real quick, because if the probate court is the only court to be able to determine the sufficiency, the legal sufficiency of the claim, the circuit court can't do that. And so if you're all were trotting along in the circuit court forum, that's not where that is supposed to determine. I think it's the case of Bell that says that the sufficiency of the statement of claim is to be determined in the probate court. And it really makes sense because that's what the probate courts do on a day-to-day basis. Circuit courts don't do that. So anyway, that certainly is the concern. Our concern is simply if that determination of the rights and the obligations was not met, then we certainly don't have jurisdiction and we can't do anything. So.
And I hear you, Your Honor. Let me address that point in this way. Obviously,
and then wrap up.
And then wrap up. I will, Your Honor. I'll make it one and the same, which is
Sure.
that the remedy we're seeking, of course, and we believed that the allowing the independent action to go forward was a determination that it was timely and proper. If this court does determine that there was no jurisdiction, I would request that if that order comes out, that it gives sufficient guidance such that the circuit court knows that it needs to go, that the pending independent action, which is, as Sue Silverman pointed out, is currently stayed, remains stayed until the probate court takes and resolves those issues. If the court's determination on the jurisdictional point is that it hasn't been sufficiently resolved, then the probate court needs to know that it needs to take it back. Obviously, we saw it a different way, but I hear what you're saying. Thank you.
Thank you both very much. It's a little more interesting than I like, actually. But we will move to our last case on the docket, which is GGH11 versus Cheval. See Ms. Marks, but I don't see Mr. Miller.
I don't see Mr. Miller either. He was at rehearsal on Friday.